Good morning, everyone, and thanks for joining the Clallam EDC Coffee Chat, Coffee with Colleen. We are really pleased to have our county's prosecuting attorney with us this morning, Mark Nichols. He's going to brief us on the legal aspects of things happening at the state and county level, and just a few housekeeping items before I let him take it away. If you'll keep yourself on mute, or I will put you on mute. And if you have questions, Mark is willing to answer them as we go along. So you can either raise your hand and I'll call on you, or alternatively, you can put your question in the chat. So with that, Mark, again, thank you so much for joining us and spending some time with us this morning. And also this is recorded, and so we'll have it up on our website later today if you'd like to share it with anyone. And that's it for me. So Mark, take it away. Thank you.
Great. Thank you, Colleen, and everyone. It's so great to see you. I'm excited this morning to share some information with you that's been trending within the world of prosecution. Every quarter, I meet with the other 38 elected county prosecuting attorneys, and we compare notes regarding what's going on, and out of that comes some issues that are trending. And so I have put together a PowerPoint presentation, and I'll go ahead and share screen in just a moment here. If I can navigate my way through the technology. Let's see, can folks see the presentation?
Yes.
Okay, wonderful. Thank you. Great. And so with that, I'll just start with a bit of a disclaimer. This presentation is intended to provide some general information. It is not, however, intended as a source of legal advice. And so should you have questions or foresee the need for legal advice, as always, I encourage you to please consult with a competent independent attorney. I'll start with a bit about your county prosecuting attorney's office. Just as an overview, the Office of County Prosecutor is one of a handful of constitutionally mandated elected county offices under Article 11, Section 5 of our state's Constitution. It is a nonpartisan office in Clallam County by virtue of a 2020 amendment to our county's home rule charter. Many counties still operate under a model whereby the Office of County Prosecutor is partisan. That's a disfavored model, in my opinion, really because I think people at the end of the day just want to have a prosecutor who's going to follow the law with partisan politics as a side issue or not playing a role at all. The prosecuting attorney's duties are not found in the county's Human Resources Department on a piece of paper. Instead, like all of the others county elected officials, they can be found in Title 3627 of the Revised Code of Washington. And while the prosecutor has many duties, they are most known for prosecuting violations of the criminal law, which is what, generally speaking, the public has the greatest appetite for. People tend to want to know who got in trouble and what for. Prosecutors also are responsible for serving as in-house counsel to county government. And in that capacity and role, they represent the county in legal proceedings and serve as legal advisor to the county's elected officials, appointed department heads, and such. And is to seek the just result. It is admittedly subjective. The concept and notion of justice generally takes on a very individualized definition when I speak with different people. And the mission statement is drafted that way on purpose. When fully staffed, your county prosecutor's office is comprised of 28 full-time equivalent positions. We've got 14 attorneys, a dozen support staff, and 2 victim witness coordinator positions. I like to underscore that the prosecuting attorney's office does not employ investigators. Instead, we defer to the men and women of law enforcement to investigate alleged crimes. And if there's a need for other types of investigations to incur, we bring in outside resource. The reason for that is because it actually takes a whole separate independent skill set to know how to conduct an investigation. And so the men and women of law enforcement have gone through the basic law enforcement academy and understand how to conduct investigations according to best practice. And in the event there's a need for a civil investigation, there are also best practices. But those are skill sets outside of our area of specialty. Also, we have a vested interest in not becoming witnesses in investigations that could come to our office for prosecutorial attention. And so rarely a week goes by when I don't have somebody emailing or reaching out by phone asking for me to have the prosecutor's office investigate something or someone. And almost always my response is to please notify the appropriate branch of law enforcement or consult with an attorney as necessary. We have 4 divisions within your county prosecuting attorney's office. Criminal division, which is responsible for prosecuting adult felonies in Superior Court, adult misdemeanors and gross misdemeanors in the district courts of Clallam County. And of course, we have 2, one located in Central County and one located in the West End. Judges Newport in District Court 1 and Judges Hannafy in District Court 2 shepherd those calendars and caseloads. And we're also responsible for prosecuting all juvenile crime in Clallam County, except for that which occurs in areas of federal jurisdiction, say, for example, Olympic National Park, or that may occur on tribal grounds. And I'll talk more about juvenile crime as we move through the program. Our civil division is comprised of 2 standalone general practitioners. We also have a family support division, which falls under the broad umbrella of the office's civil division. And our family support division is responsible for determining paternity and then engaging in support enforcement actions. I've mentioned our support staff division, comprised of a dozen support staff who are instrumental to the work of the office. Frankly, if the support staff chose not to show up on any given day, the office would be hard pressed to transact business because they have a skill set that many of the attorneys, in fact, most of them simply don't possess. And then we have 2 victim witness coordinator positions. They are invaluable in helping to shepherd the provision of victim rights under Article 1, Section 35 of our state constitution, and then the Crime Victim Bill of Rights in Title 7 of the RCW, and the Juvenile Victim Crime Rights Bill in Title 13, excuse me. And so those positions are very, very important, wind up interfacing with crime victims, usually very quietly behind the scenes, helping them to navigate the operation of the criminal justice system, answering questions, helping to coordinate and schedule meetings, among other tasks. We are, by numbers, the largest law firm on the North Olympic Peninsula. Shifting to my first topic of the day, I wanted to talk a little bit about sentencing reform from a macro level, stepping back and taking a look historically at what's happened in the state of Washington, because I think the past helps to inform where we are today and perhaps where we're headed moving forward. And so for those who are native Washingtonians or who were around back in the early 1980s, you may recall the sentiment at the time, but it was one of being relatively tough on crime. There were quite a few conversations surrounding no nonsense need for reform in the law. And what came out of those discussions was the truth in sentencing movement, which culminated in the adoption of the Sentencing Reform Act, which went into effect in 1984. The goal of the act was to reduce disparity between imposed sentences and actual time served. A few key features of Washington's Sentencing Reform Act include that it shifted away from indeterminate sentencing, where judges had broad discretion and parole boards could release inmates early, to a determinate system where sentences were fixed based on a grid that provided a range of sentences for different offenses and that served to limit judicial discretion. And when I reference a grid, I literally mean something similar to what you might have experienced in an 8th grade math class with an X and Y axis. Along one axis is the seriousness level of the offense for which an individual is being sentenced. Along the other axis is their offender score. Generally speaking, the offender score is calculated by virtue of each felony conviction ranking as a point. There's a maximum score of 9, and the higher your offender score on the one hand, and the more serious the offense for which you're being sentenced on the other, the higher the sentencing range within which the judge needs to sentence you. There are abilities for judges to make downward departures and upward departures based upon specific factual showings. The other thing that the Sentencing Reform Act did was to abolish parole, meaning that inmates would serve their entire sentence without the possibility of early release. About 9 years later, the voter initiative approved in 1993 made Washington the first state in the country to establish a so-called 3 strikes you're out law, mandating that a person convicted of certain felony offenses on 3 separate occasions would be automatically sentenced to life in prison without the possibility of parole. And notably, more than 76% of the voters in the state approved the measure in November of 1993, again, providing a snapshot indication of the sentiment of voters in Washington state in 1993 in the follow-up to the adoption of the SRA in 1984. While the initial goal of the Sentencing Reform Act was to reduce disparities and ensure that offenders served their sentences, the abolition of parole and the introduction of longer sentences have been criticized by some for their impact on rehabilitation and community safety. Today, Washington still has a determinate sentencing system. However, there have been reforms and changes to the sentencing guidelines over the course of time. In Washington, second chance legislation encompassing initiatives aimed at reducing recidivism and supporting successful reentry for individuals with criminal histories, including programs focused on job training, housing, and addressing substance abuse and mental health challenges, have been brought forward over the years. And to give you a real-life example, I'll touch on House Bill 1125, known as the Judicial Discretion Act. This is a proposal that was brought forward for the second time during the legislative session that just concluded. House Bill 1125 would have established a process for certain persons convicted of a felony offense to petition the sentencing court for a modification of the original sentence upon meeting specific eligibility criteria. And as happens with legislative proposals, our lawmakers, our state representatives, for example, senators, are presented with testimony from supporters of any given proposal and also opponents. And so the following talking points are excerpted from the House Bill Report. Proponents or supporters of the Judicial Discretion Act argued that sentences that no longer serve any penological purpose are not in the interest of justice, and disproportionate sentences should never be ministerial. Further, that giving someone a lengthy sentence at a young age does not incentivize rehabilitation, and the price of housing incarcerated persons has greatly increased in the most recent decade. And they also pointed out that a lot of money will be saved by letting safe people out of confinement and redirecting funding to victim services and law enforcement. On balance, opponents of the Judicial Discretion Act argued that this bill would jeopardize public safety. Oh, Colleen, I see you've got your hand up. Go ahead.
Well, why is it that in the most recent decade, the cost of housing incarcerated people has gone up? I would think it'd be fairly consistent with CPI. Is that not the case?
I don't think so. There's a number of factors that I think are driving up incarceration costs, and they range from costs of providing medical and dental services to the inmate population, there has been an increase in what's called prison programming. And when I say programming, I speak to the existence of programs that are designed to enrich the experience base of the prison population. These are programs designed to help folks advance their education, perhaps obtain a trade level certification so that upon release, they're better situated to become a productive member of society, working, earning money, paying taxes, etc. Another driver that has influenced, I think, the treatment of prisons involves the liability attendant to operating the facilities. The amount of litigation that has occurred over the course of time has made for a more expensive undertaking. And so add to that union activity with respect to correctional employees, salaries increasing, sometimes in concert with cost of living. Sometimes they fall behind and they play leapfrog and catch up and wind up a bit ahead, as the case may be. But it's been an expensive undertaking. And the facilities themselves are aging. Washington State has not been building new prisons. Rather, it's been in the process fairly quietly over the last 10 years or so of shuttering the doors on different prison facilities, reducing the number of prisons, and they're dealing with aging facilities at the same time. So the overhead costs for maintenance and upkeep, I think, are probably on an upward trajectory.
Thank you.
You're welcome. And so opponents, in response to the proposal, pointed out or argued that the bill would jeopardize public safety, re-traumatize victims and their families, and fail to address the irreversible damage caused by violent offenders who have demonstrated a willingness, in a number of cases, to assault and kill other people. They further argued that the government should protect citizens from harm and uphold the laws on the books. And they pointed out that the bill would cause additional harm and reopen victims' wounds. And the reason that's important is because if you think about what happens through the course of a prosecution for, say, a violent crime, there is the act itself that occurs and results in the immediate victimization of the victim in the case. Then they are put through the process of working with the prosecution in relation to holding the offender accountable. Many would say that that has the effect of re-traumatizing them or re-victimizing them, if for no other reason than they are oftentimes put on the stand and made to recount the violent events that occurred at the hand of the state conducting a direct examination, and then they're further subjected to a cross-examination. They have an opportunity at sentencing to make what's called a victim impact statement. That may be cathartic. It may also be triggering and traumatic for them a third time over. And at that juncture, many would argue that the system has run its course. The book should be closed, and the victim should have the ability to proceed forward in life with an effort in mind to try and obtain closure, if that's even possible. The notion of receiving a phone call or a letter from your local prosecutor's office alerting you to the fact that an inmate has filed a petition seeking to be released earlier opens the wounds previously closed and has the effect of arguably re-traumatizing a person for a fourth time over. And so for many, they were quite sensitive to that set of concerns and made sure that the legislature understood that that was on their mind. I mentioned earlier that I'd talk a little bit about juvenile offenders. I have long believed that one of our best investments is in our country and certainly our county's youth population. And so we track this pretty closely. The chart on display reveals what has been happening over the last 4 or 5 years or so in Clallam County. And it tells a story which is quite concerning from my standpoint. The top row reflects the number of cases referred by all branches of local law enforcement to the county prosecutor's office in which there's a suspected juvenile crime. And so what you can see is that in calendar year 2021, the office received 121 referrals for juvenile crime. if you compare that to what happened in 2024, we were at 292. If you look at what's happened the first 6 months of 2025, we're on course to hit about 246 referrals by the end of the year. However, I think that number is likely to increase and eclipse 300 because we are on notice that we're going to receive a larger volume set of referrals from SQUIM for an incident involving the high school that has been publicized recently. And so the referral numbers have climbed precipitously. There's a number of cases that have been diverted under Washington state law for a juvenile who's referred for their first misdemeanor or gross misdemeanor offense. They are entitled by right to be diverted as compared to prosecuted. And so that row of diversions speaks to that activity occurring. The next row reveals AOC cases charged. AOC refers to the Administrative Office of the Courts. I'm drawing the cases charged data from their public-facing profile. And again, if you compare 2021 to 2024, what you can see is that we've had over a 300% increase in the number of cases being charged. There are always going to be cases that are declined for prosecution, either due to insurmountable proof problems. There could be a statute of limitations challenge that arises, or if it's a case involving a violent crime with a victim, we're very attentive to working with those folks to make sure that they're in a condition to be able to support the prosecution effort. And if they're simply not at a particular point in time, we may decline to prosecute and come back and revisit that at a later date. I think the takeaway is that the numbers are concerning. We are seeing a relative explosion in youth crime in Clallam County by the numbers. It is provable, verifiable. Many people are asking why this is happening, and I personally believe, based on feedback from a number of disciplines, that this was expected as a result of everything that occurred by and through the pandemic. And so the physical distancing or social distancing measures that were put in place in an effort to mitigate the contagious concerns surrounding COVID-19 had the effect of disrupting younger people's lives. If you think about it, what was going on when you were back in high school, that's where you were interacting with peers, meeting friends, participating in sports or band, as the case may be, socializing. You were learning how to interact with other people. You were refining your judgment skill, developing discretion with respect to interpersonal skill sets, and understanding the difference between right and wrong as you navigated your formative years. That was all terribly disrupted with no notice. And so psychologists, criminologists have both surmised for years that we would incur a consequence from that for this generation. This may be evidence of that occurring in real life here in Clallam County. This reflects a breakdown of the crime categories. The concerning thing about this is that if you look at 2022 as the best example, person crimes eclipsed the entirety of society and property crimes occurring at the hand of juvenile offenders. So 53% of cases involved assaults, sex offenses, or harassment, for example. Property crime reflected in pink includes theft, malicious mischief, vehicle prowl, those types of crimes. That was at 15%. Society crimes, including minor in possession of alcohol or cannabis, as the case may be, were at 32%. There was a pretty significant correction between 2022 and 23, and then a bit of a resurgence in person crimes in 2024. But most concerning is that from a trend perspective, for each of these 3 years, there was more person crimes than there were either property crime or society crimes. I take the position that because we can never get away from crime entirely, if we're going to have to contend with it, it's best to have property or drug crimes be more prevalent than violent crimes or person crimes, which tend to be the most serious. And so we're a bit upside down and backwards with respect to the numbers, the direction in which we're heading with our county's youth, and also what's happening by way of crime category. Another hot topic within the world of not just prosecutors, but I think probably public defenders and the broader criminal justice system involves what's happening in relation to impaired driving cases and other types of cases that require services out of the Washington State Patrol's Toxicology Lab. And so, as folks know, the men and women of law enforcement are constantly interfacing with citizens in relation to cases that may start with observations of bad driving and that evolve into an impaired driving investigation, a DUI investigation, as it were. In those cases, the men and women of law enforcement will oftentimes, based upon observations made, perhaps the odor of alcohol in an individual's breath, they will apply to a judge for a warrant that allows for blood to be drawn from an individual's body. That blood sample is then sent by the men and women of law enforcement to the state tox lab. As of April of this year, if a blood sample is sent to the tox lab and the request is simply to test for the presence of ethanol or alcohol, the average turnaround time was about 11 months, after which the law enforcement officer would receive the test result back and then forward it to the county prosecutor's office. If we change the hypothetical a bit and envision a scenario where a law enforcement officer stops someone for bad driving, contacts them, they don't smell alcohol, but the person, through their actions or lack of in say the field sobriety test, demonstrates impairment, the officer may suspect that they're under the influence of something else that they can't smell. And so in that case, they may go through the process of obtaining a warrant that allows for blood to be drawn, and they could send it into the lab requesting that the test occur not just for ethanol, but for other compounds like cannabinoids or amphetamines, just to name a couple of examples. In those more complex cases, the average turnaround time, again, as of April of this year, was about 22 months. Which is just shy of the 2-year statute of limitations that the state has to comply with in charging people with driving under the influence. The reason I'm talking about this is because this is less than an ideal situation for our state to find itself in. In a best case scenario, if a person is stopped for bad driving and it is believed that they are operating a motor vehicle impaired, the time between the law enforcement officer stopping them and arresting them and booking them into the county jail and the state filing criminal charges should be short. I think that's, generally speaking, from a public policy standpoint, a better way to do business. It's a best practice. Given the delay that is occurring at the state lab, it is instead our practice to oftentimes decline to file these cases initially, pending receipt of that blood result as a precondition to making a charging decision. And the reason we do that is because there are a number of just frankly bad drivers on the road, people who are inattentive. They might have been looking at a cell phone. They might have just been daydreaming. And so they may stray out of their lane or evidence bad driving. But that does not driving under the influence make. Oftentimes we need to have an actual verifiable blood test to be able to prove the presence of controlled substance in a person's system. And I see a hand from Dr. Maxwell. Please go ahead.
Yeah, thanks, Mark. Just curious about that turnaround time between 11 and 22 months. Is that a staffing issue, or I assume it might just be related to caseload, but it seems like the assay itself, the machines to do this are pretty quick. So it must just be they don't have enough machines or not enough people run them. Is that what's going on?
You are correct on both fronts. And so one of my former assignments was to serve as chair of the state's Forensic Investigations Council, which in consultation with the chief of the State Patrol oversees the Forensic Laboratory Services Bureau at the state level. within which we find the state tox lab. To your point, the situation's actually far worse than many people realize. And Colleen, I'll get to you in a moment because I do see your hand. The statewide backlog is currently sitting at about 16,800 cases, most of which are impaired driving work. And the backlog does exist because, number one, there have been a shortage of facilities to house the necessary equipment and the people to keep pace with the demand. On the other hand, staffing has been a significant challenge for State Patrol. Many of the facilities where the machinery is located are close to the I-5 corridor where rents and housing costs are through the roof. And these positions do not pay particularly well. Add on top of that, the fact that State Patrol has a quite robust background check process, including a polygraph, psychological evaluation, and many people simply are washing out through the process and never getting to the point of receiving an offer. But for those who do, they're oftentimes excited to get the offer and then dismayed when they discover that they really can't afford to take the job, given the high cost of either purchasing a home or even renting in and around the I-5 corridor. The problem that's developed has been, frankly, a couple of decades in the making. And as you can see from the numbers here, the State Patrol anticipates the backlog to peak in November of 25, with a 50% decrease predicted in 2028 and the backlog eliminated by 2030. And so in the same way it's taken us a while to dig ourselves a hole as a state, it's going to take us a while to fill it in and get back up on level ground again. It used to be the case, say 20 years ago, that the Tox Lab could turn results around inside of 30 days routinely. And that was very helpful because it would allow for county prosecutors' offices, for city attorneys to prosecute these cases more timely with a reduced delay window between the arrest and the beginning of the prosecution effort, based on circumstances, again, that time frame has really been enlarged, which is not helpful for public safety, especially when you're dealing with a higher risk offender who we don't want to see back out on the road. Colleen, go ahead.
Yeah, so just to clarify, all law enforcement officers in Clallam County have to send the blood sample to the State Patrol toxicology lab, and do other larger cities, say Seattle, do they have their own? And could you possibly use that?
So to your first question, yes, the general rule or the default is that if you have a tox sample, it gets sent to the state's toxicology lab. There is an ability, technically speaking, to use private labs. A good example is one named NMS, which does private lab testing. And if you use NMS labs, generally speaking, you'll get your result back within about 30 days. And that sounds great. It is great. The problem with using a private lab is that if the defendant in a DUI case opts to advance their case to a jury trial, which is their right, the state's burden is going to be to produce the lab technician to testify on the stand regarding their testing, the results, etc. The private labs will bill for the use of their personnel, and oftentimes it's an hourly rate. We will have to bring them in from wherever they're coming from, house them in Clallam County for potentially one night. If it's a more involved trial, it could span more than one night. We have to feed them, reimburse them mileage, and so the cost rises significantly at a level that outpaces what many small jurisdictions are able to pay. If cost were no issue, we'd use NMS labs every time, or a counterpart private lab, just to speed things up. We're just not in a condition to be able to do that.
Got it. Thank you.
You're welcome. Dr. Maxwell, did I answer satisfactorily your question?
Perfect. Yeah. Thank you.
Okay. And so The State Patrol will continue to see the backlog increase as the State Patrol trains new scientists. I will note that in my conversations with folks at the Tox Lab, they speak to the fact that it takes the better part of a year to get a new scientist trained in protocol. And they have to be very deliberate about how they do this, because these individuals can be called to testify on the stand, and their credentials, their training, and their experience will all be put on trial in the same way the defendant is being. And so it's a less than ideal situation. I wish as a state that we had not allowed this problem to develop. There are some good things that are happening, albeit a little later than would have been ideal. And so, for example, there's a new lab that has opened in Federal Way. With that new lab, they have some more workstations. They're able to bring on some more forensic scientists. And it's through that additional resource that they're going to be able to turn the tide and start getting caught up in relation to the backlog. Involuntary Treatment Act proceedings are another hot topic, really here in Clallam County, not as much statewide. And the reason I say that is because the Jamestown tribe is building a 16-bed psychiatric evaluation and treatment facility, which is currently set to open its doors in mid-2026, based on my last conversations with the tribe. Unbeknownst to many, the county prosecuting attorney is statutorily required to represent the individuals or agencies petitioning for commitment or detention in these proceedings. And that's based on a requirement found in RCW 71-05-130. And so at present, if somebody is in a condition where it's believed that they're presenting as a danger to themselves or others, and we see people come into the criminal justice system who check one or both boxes, it is common that they will be evaluated by a designated crisis responder, otherwise known as a DCR. The DCRs are generally found in one of the county's two designated mental health providers. So Peninsula Behavioral Health on the one hand, which generally caters to the needs of populations in Central and East County, and West End Outreach, which caters to the needs of populations in the West End of the county. If the DCR determines that an individual is gravely disabled, that will begin a process which really entails a civil litigation focusing on whether they're going to be committed against their will and remanded into the custody, say, of Western State Mental Hospital for a period of time prior to being released in a condition where they can attend to their own needs at a responsible, safe level. This is something that we know is going to be a heavy lift for Clallam County. We've never in our history had a 16-bed evaluation and treatment facility, and so this is a first of its kind undertaking. Historically, because we haven't had one of these facilities, we've had to transport individuals from Clallam County who were deemed to be gravely disabled to other counties that did have these evaluation and treatment facilities, the closest being our neighbor to the south, Kitsap County. Now that we have our own facility, we're going to be able to house these folks locally, which is a game changer. But again, it's going to come with 16 beds. I anticipate many of which will be filled on a relatively stable ongoing basis. And so we've looked to some other counties that have a 16-bed evaluation and treatment facility that are of similar size, a good example being Grays Harbor County. It's comparable to Clallam. And what we've discovered is that in their superior courts, they've had to structure 2 days a week to have calendars on which ITA proceedings are litigated. We anticipate the same need will come to exist in Clallam County, and so we are actively working well in advance of the 2026 opening with the Clallam County Superior Court, the Public Defender's Office. The Prosecutor's Office is helping to spearhead this effort with the tribe, obviously, representatives from PBH, West End Outreach, other stakeholders, so that we can develop and fashion a responsible plan to meet the need so that nobody's caught off guard when the doors open. Because cost is always a consideration, the one silver lining here involves that under state law, the state of Washington is required to reimburse the county for costs incurred in these proceedings. And so the county will need to foot the bill up front, but then on a quarterly basis receive reimbursement for the state, or from the state rather. And so that's good news for Clallam County and its taxpayers. And if we didn't have that reimbursement model, frankly, I'm quite not sure what exactly we do. Colleen, go ahead, please.
Yeah, is the Jamestown facility only for involuntary treatment, or will it also be for people that voluntarily go in for treatment?
I don't know the answer to that question. I can speak with certainty to the fact that it will certainly house individuals who are the subject of ITA proceedings. Whether it's going to have a broader scope, I can't answer with confidence at this juncture, but I can look into that and provide you an answer under separate cover.
Thank you.
You're welcome. And so this is it's an effort that's going to impact, again, the Superior Court for Clallam County, where these proceedings are required to occur by operation of statute. Your county prosecutor's office, the public defender's office, the county clerk's office. It will have collateral impacts, I think, to the designated mental health providers within the county as well. And so we'll all learn together how this effort unfolds, but more to come, and doors to open sometime in mid-2026. I'll touch on artificial intelligence only because this is a burning hot topic within the world of prosecutors, and I think law enforcement as well. From the Oxford Language Dictionary, artificial intelligence is a noun defined as the theory and development of computer systems able to perform tasks that normally require human intelligence, such as visual perception, speech recognition, decision-making, and translation between languages. What I can tell you, the Cliff Notes version takeaway, is that if you look at the policing profession and the prosecution or legal profession more broadly, these are professions where you still need good old-fashioned human beings to do the job. And so there have been some conflicts that have developed over the last year or two in particular, wherein attorneys on the one hand and/or law enforcement on the other have found themselves in trouble with the courts because they have relied too heavily on artificial intelligence in relation to either report writing in relation to the work of law enforcement, or brief writing in relation to the work of attorneys. And so I think artificial intelligence is a fantastic thing as a secondary resource for research purposes for both disciplines. However, it can't replace the need for a human being to actually do the work, especially because all of these documents that I've referenced, police reports, pleadings filed with the court, many of them are signed under penalty of perjury. Others are submitted as officers of the court to a judge, and they simply have to be correct. And the reality is that as smart as AI is, it doesn't always get things correct. And so if you rely too heavily on it, sign your name to a document attesting to the accuracy of the information contained therein, only to discover that it's actually incorrect, that can invite trouble on the ethics front for attorneys, the possibility of sanctions, and for law enforcement officers, it can invite attention and focus on their integrity, their veracity, their reputation for being honest, and there are all sorts of career implications that can stem and flow from that. The last topic I'll touch on is public defense caseloads. If folks have been paying attention to criminal justice issues, they may know that there's been quite a bit occurring over the last couple of years in relation to public defense caseload standards. We've had them on the books for years in Washington State, dating back to 2012. Starting a couple of years ago, there was a push from the State Office of Public Defense to have those standards revised in a way that would significantly reduce the caseloads of public defenders by about 2/3 or so in total. And so just recently, on June 9th, the state Supreme Court issued an order that will require public defenders moving forward to start capping caseloads at lower levels than present. There's a 10-year phase-in period that's been provided, which is helpful. And by 2036, it's anticipated that the number of cases a public defender can handle will be reduced by about 2/3. This raises a number of collateral considerations. On the one hand, unless there's a significant reduction in law enforcement referral and prosecutor charging activity, there's going to need to be more defense attorneys to keep pace with system demand. And so we speak in terms of there being a supply-demand challenge that will present. It will be exacerbated by virtue of the fact that the state is currently experiencing an attorney shortage, both in relation to the public defense discipline as well as the prosecution discipline. And even if you look at, say, Clallam County's private sector bar as an example, for those who've been around for a number of years, you may know that there's been a great many practitioners who've retired, but we haven't had as many new attorneys showing up to replace them. And so there's a void within the local bar. There is a shortage here in Clallam County, as in so many other places across the state. That's going to be something we're going to have to contend with, because the concern is that if we don't have enough defense attorneys to appoint in circumstances where a person's been charged with a crime and deemed indigent by a court, something's going to have to give, because under the Sixth Amendment to the U.S. Constitution, a person is entitled to counsel at public expense if they cannot afford an attorney on their own. It's a constitutional requirement. And so if the state files a case and there's no public defender to appoint to represent the accused, a judge may very well see fit to dismiss the case, believing that that is the lesser of two evils as compared to allowing it to continue through the system with a clear constitutional violation occurring, as evidenced by the lack of assignment of an available defense attorney. And so if we think about how this could play out and how it has already started to play out in places like Benton County, Franklin County, and the Tri-Cities area, they are already experiencing a crisis level of defense attorneys in shortage. And so there have been serious violent felonies that have been filed by the state only to be dismissed by the court because there's not an available defense attorney. As you might imagine, this does not go over well with the community at large. It rightly raises significant public safety concerns. It has drawn criticism from the policing profession for completely understandable reasons. And so it's an outcome that is best avoided at all costs. My concern is that if we find ourselves as a county in the same position in the years to come, and we're not able to see all the cases that are referred being prosecuted at a level that comports with public and community expectation, people will start to lose confidence in the system. And I think they already have to some degree, based upon so many features of what's occurring within our state, policy changes that are occurring, funding shortages that are influencing service levels. However, as they lose confidence, what we may see is people start to stop reporting crime to law enforcement under the belief that what's the use? Nothing's going to happen if I bother to report. And what stems from that as a third evolution is the surfacing of vigilante justice, where people out of extraordinary frustration opt to take the law into their own hands because they don't believe that the system is operating adequately. These considerations were spelled out by me in a communication I sent into the Supreme Court during the comment period when it was considering revising the caseload standards. I don't know what value the court assigned to that type of commentary. I just know that what it did do was build in a 10-year phase-in period for these new caseload standards as compared to the 2 years that had been suggested. So they bought us some time at a minimum. The cost issue is also a huge problem. There's been quite a bit of attention paid to this. And by way of late breaking news, I will note that just yesterday, Division II Court of Appeals issued a published opinion in which it overturned the Thurston County Trial Court's decision in a case captioned Washington State Association of Counties versus State of Washington. In that case, the Thurston County Superior Court had originally dismissed the county's complaint for declaratory and injunctive release based on a lack of standing. The Court of Appeals opinion concluded that the county is in fact satisfied the state's test for standing. The Court of Appeals also underscored the public importance of the issues that are at the heart of the litigation. And so unless the state of Washington opts to appeal the Division II opinion to the state Supreme Court, the matter is going to head back to trial in Thurston County Superior Court. What will be on trial there is the issue of whether the state of Washington has essentially abandoned its duties in relation to the need to fund public defense at a satisfactory level, given the constitutional mandate for indigent defense across the state. And so we'll all learn together how that plays out. Suffice to say, it's a very important issue for all Washington counties. Here in Clallam County, as I've listened to our commissioners and reviewed some of the documentation, what I understand is that on an annual basis, Clallam County pays roughly $2 million towards the cost of indigent defense. The state of Washington contributes about $70,000 per year. In many other states, the state pays the lion's share of indigent defense costs, and local jurisdictions are left to pay but a fraction of that. And so we find ourselves in an opposite position here in Washington, not only in relation to our funding model, but also because we don't have a unified Office of Public Defense that oversees the provision of that service across the state. Instead, we have more of a patchwork quilt with different models operating in and amongst the different counties around the state. And so I anticipate that the legislature is going to be pushed to pay closer attention to this, either at the hand of a court decision or perhaps on its own. It may look at what's happening and see that this is going to be an issue that they're going to have to deal with eventually, and so they may as well take it up earlier as compared to later. Ultimately, it will be very helpful to have some guidance from the courts or some action from the legislature, and hopefully in a way that reduces the cost to Clallam County government and taxpayers by implication, because there are so many critical services that need to be funded. Indigent defense is one of them, but it cannot be allowed to eclipse everything else that needs to occur as part of county government, the broader public safety effort, the operation of courts, policing, prosecution, just to name a few of the services provided. I never like to end talking about money, and so I like to build in a fish picture. And this is one from, I think, last fall on the Quileute River. There are still salmon in it, and this was a large buck that I threw back into the system. Prosecution, like so many other disciplines and jobs, is one that can sometimes push you. And so my piece is found on the West End Rivers in Clallam County, where I spend some of my free time. And with that, I'm going to stop screen sharing. And I would welcome any questions that folks have, either about content presented in the program, or if you have another question, I'm glad to answer that as well. And I see one from Steve Paleo. Please go ahead.
Great, thanks, Mark. I really appreciate you presenting today. Your comments in the last few minutes just hit a nerve with me. I recently finished reading and analyzing the crime statistics for the recently published City of Port Angeles Police Department annual report. I then went out and I spoke to Chief Smith, and he just reminded me something that kind of shocked me to my core, that the data is really skewed based on the levels of staffing. And I'm hearing the same things kind of echoed by you as well. He even said something like state of Washington's like, 50% per capita, the number of police force or something of the rest of the country. So he's really just implying that, less police results in less crime being reported and therefore prosecuted. So I guess this is where I'm struggling the most. Do our crime statistics actually have any value? It sounds like there's more crime, but we just don't have the capacity to tackle it. And then this ultimately questions me, how safe should I feel in my community? Am I in fact losing confidence in the system, as you said? So what do you think is the best way for me to evaluate if we're actually making progress?
Steve, that's a fantastic question, and there's probably 3 or 4 critical points to address within it. The first thing I'll say is that even though I'm a native Washingtonian, I was born and raised in Seattle, spent about the first 25 years of my life there. And at this point, I've been on the North Olympic Peninsula for longer than that. And so I'm not sure what I should call myself, but I know I'm a native Washingtonian through and through. I, I am able to hear from the other 38 county elected prosecutors what's happening in their jurisdictions. Beyond that, I have attended different national conferences where I'm able to speak with district attorneys and elected prosecutors from other states. And it provides a level of perspective that really has informed my opinion regarding a few things that we need to work on as a state. Um, by way of comparison, what we know is that Washington is towards the absolute bottom of the barrel with respect to the number of law enforcement officers that are patrolling the streets on a per capita basis. This is something that the Washington Association of Sheriffs and Police Chiefs has tried to underscore and highlight for years to our legislature. I think it's probably one of the things that may have come up in your conversation with Chief Smith. His remarks are, in fact, accurate. We may not be at the very bottom, but we're darn near there, and we have been there in years past, is my understanding. And so what that speaks to is that in Washington state, as a state, we have not seen fit to prioritize policing at a level commensurate with most other states around the country. Again, if you're from Washington and you've never taken the time to look at what's happening around the nation, you might not have that basis for comparison and understand our relative rank. That is where we are. Similarly, in relation to public defense, which I've just spoken through, we are in the minority of states in how we approach this. We have a patchwork quilt public defense model. The state pushes the cost of public defense down on counties and cities for that matter. And so there's some argument that the state's failing to prioritize and meet the obligation that it has to fund indigent defense as part of a broader criminal justice system. And so to your question, I am very concerned about how people feel about public safety. During my budget pitches with the County Board of Commissioners, one of the things that I often remind them is that public safety is, well, while we're at the budget meetings to talk about dollars and cents, I don't want to lose sight of public safety, which is an intangible, priceless asset. Once you lose it, in my opinion, and in my observation, it becomes extraordinarily expensive to buy it back. And so you are better off doing everything within your disposal to ensure that the community feels safe. That is a heavy lift because it's a subjective determination for each person. I think what needs to happen is that we need to have prioritization in the state of Washington and at the county and city level, respectively, in relation to policing as the first line of defense, and certainly as to prosecution, indigent defense, and the courts as well, all of which come into play after the fact in a reactionary mode to deal with what happened after the police respond. I think that in response to a question in the chat room from John Temple, what can attendees to this call do to help? What you can do to help is reach out to your state representatives, former Commissioner Theringer, but now State Representative Theringer, Representative Birnbaum, Senator Chapman, and express your thoughts and opinion and views regarding all things public safety related. Let them know if you feel that the state's heading in the right direction. One thing I'll note that is interesting and perhaps a bit encouraging to me is that if I think back to House Bill 1125, the Judicial Discretion Act, I mentioned that that was the second time this legislation has been proposed, and it died on the vine towards the end of the process. We don't know why that happened. Many believed that the second time would be the charm and that proponents of that legislation were going to persuade the legislature to adopt it. And we would see that become law and likely result in offenders being released from prison earlier than they were otherwise sentenced to be. I don't know whether the lack of legislative support is representative of the state of Washington starting to reach some form of a tipping point, or if instead something else explains it. But I try to listen to, excuse me, discussions from across the state, and I know that there have been vibrant discussions occurring with advocacy across the spectrum in relation to challenges surrounding homelessness, crime, drug use, all of these challenges that have been around for ages are currently in the forefront, I think, of many communities' consciousness. And I feel that there may be some traction occurring with respect to people relating a expression of concern to state representatives regarding there needing to be balance, in a word, in relation to how we're trying to navigate so many of these challenges, these social ills, these public safety matters. And so I'm hoping that we're going to see greater prioritization of public safety in the state of Washington by and through our state legislature, actions of our governor, and even at the local level. It's difficult because there's not enough money to go around. Public safety is comprised of core services, which is something I like to remind government. It's not a discretionary function. It's something that is required to occur. And so I hope that it is funded at a level that stands up a response that allows for people to feel safe.
All right. Well, thank you so much, Mark. With that, I think we're going to close out the meeting. And I think we all agree of the level of importance of public safety. So thank you, everyone. We will have this recording up on our website later today if you'd like to share it with anyone. And again, thank you, Mark, and everyone. Enjoy your day. Thanks, guys.
You as
Bye-bye.
well. Thank you.